Going to be by David Maass, familiar name, familiar firm to us, Alley Moss, Rogers and Lindsay. He's an associate at Alley Moss, Rogers and Lindsay in Palm Beach. You know him. Focuses on yacht transactions, represents clients who are buying, selling, and chartering yachts, and a really, really, really good friend to IYBA. He does a lot of work for us, pro bono.
Thank you. Good afternoon. I'm a transactional lawyer, which means I don't litigate, I don't go to court, I don't even meet with clients that often. So this is actually only the second time since COVID started that I've had to put on real pants. And the first time actually was when we filmed Yacht Sales and the Law. So I want to thank the association for forcing me to be a human being. We're going to be talking about three things today. They are engine emissions, crew immigration, and foreign trade zones. Some of this is going to be a refresher, some of it may be new. The first thing I want to talk about with engine emissions, this has been a major issue the last few years. I think most people know for marine diesel engines, we're not talking about gas outboards here, but marine diesel engines, you have two sets of requirements relating to emissions, and they are requirements by the IMO under MARPOL Annex 6. These are the EIPPs. And then you have EPA requirements under the Clean Air Act. EIPPs are required for every engine, including generators of power 130 kilowatts or greater on any vessel built after January 1st, 2000. They're also required if the vessel is older than that, but the engines have been replaced since then. So if you have an older boat, you don't think EIPPs are required, it's always a good idea to make sure the engines are original. EIPPs are a frequent issue that come up in yacht sales. I would say, how many people here have had to deal with EIPPs either through a price adjustment or as a post-closing item? Yeah, these often they throw a wrench in deals. And a lot of people ask, well, why are they necessary? And I'll get to that in a minute. They are, for now, let's just say that they are legally required. If you don't have the EIPP, the certificate itself, you can order it from the manufacturer through their local distributor, but the prices are exorbitant and the wait times can be long. I think EIPPs is something that's on most people's radar, but I want to talk about something that's really come up just in the last couple of years, and that's the Clean Air Act. So as I said, there's a separate set of requirements under the Clean Air Act that applies to vessels that are U.S. documented or that are imported into the U.S. Does not apply to foreign flag vessels that are not imported into the U.S. And very confusingly, both of these requirements are divided into tiers with increasingly strict requirements, but the tiers are not the same. In fact, they don't even measure the same thing. So they're completely different requirements. Usually you don't have a certificate that says you comply with the Clean Air Act. The EPA will issue them, and some people do have them, but most don't. Typically what you have instead is a decal or a plaque on the engine itself that certifies compliance with one of the tiers. Sometimes if an engine wasn't manufactured for the U.S. market, it won't have that plaque, but if you contact the manufacturer, you can find out that it nonetheless complies, and you can even sometimes get a replacement decal. Now, why does this matter, or why in the last few years has this become an issue, even though it's been a requirement for some time before that? A couple years ago, CBP started enforcing the EPA requirements at the point of importation. So if you wanted to import a foreign-built boat into the U.S., you had to prove that the engines were EPA compliant. And I asked a customs broker, well, why did this happen? Why did they suddenly start to care about this? And he said, well, they updated their software. Now they have to check a little box that says it's EPA compliant. So they're asking for paperwork. Now, this can cause a problem because if you have a foreign-built yacht that is not yet duty paid that you bring into the U.S. to market here either under a boat show bond or in an FTZ, you may have a client who's interested in importing the yacht either because they want a U.S. document or because they want to be able to charter in the U.S. And they may discover only after closing that the boat can't be imported at all because of the engines. So if you have a client who's looking at a boat, foreign built, not imported, may want to import the boat in the future, it's very important to make sure that the engines comply with EPA requirements, because without that, you're not going to be able to import the boat. It can be confusing to confirm whether they do comply if they don't have the nice little decal that says they do. Every major engine manufacturer has environmental compliance departments. Some are more responsive than others. Caterpillar actually has a really cool app where you can enter the serial number and it'll tell you what level it complies with. So we use that sometimes. Now, I said I'd get back to why EIAPPs are important. And because people often say, you know, no one's ever asked to see this. I've never heard of anyone getting in trouble for not having this. And that's true. I've never had a client who's gotten in trouble for not having them. But at some point in the next few years, the Coast Guard or CBP is going to update their software, and there's going to be a little box that says, do they have EIAPPs? And suddenly it's going to become an issue. They'll start enforcing it, and people do not want to be caught without those. I should add one thing that there's a little bit of confusion about with EIAPPs. People sometimes say they are not required on U.S. documented yachts, and that's kind of half true. They're not required if the yacht never leaves U.S. waters. They are required for U.S. documented yachts that make voyages internationally. The update I want to give on this is that the Coast Guard recently announced that they would delay enforcement of the latest and most stringent tier of IMO requirements, which is IMO Tier 3. That was supposed to be phased in January 1st of this year, vessels built after January 1st of this year. So at the end of the year, I had at least one client who was trying to sign a construction contract to get a keel lay date before the new year so he wouldn't have to get the more expensive engines. But what ended up happening, because these engines aren't widely available yet, is that the Coast Guard said, you know, we're not going to enforce these until either the end of 2023, or if the engines become widely available before then we'll start enforcing them. Now, again, this only applies to yachts that are currently being built. So this period between now and the end of 2023, this primarily benefits builders who do not have to worry about designing and building yachts that comply with these more stringent requirements, because my understanding is that the sort of equipment that you have to put on top of the engine to comply with Tier 3 is just too large, and it has all sorts of implications for the design of the boat that just makes it not feasible. So they're not there yet, but they will be. I should add that this only applies to a certain segment of the market, specifically it's yachts. Recreational boats that are more than 24 meters in length, but under 500 gross tons, so good-sized boats, but a good swath of the market. And although you don't have to comply with Tier 3 requirements, you do have to comply with Tier 2 requirements and EPA Tier 3 requirements. So, as I said, it primarily benefits builders, but it's good to see that the Coast Guard is being realistic and not trying to enforce a requirement that, though it's on the books, is really impossible to comply with at this point. So the next thing I want to talk about is crew immigration. I have often heard people make sort of a general statement that you can't have foreign crew on U.S. documented vessels. And that's not true, because if the vessel has only a recreational endorsement, you can have foreign crew. There's no reason legally you can't have foreign crew. You can even have a foreign captain on a boat with only a recreational endorsement. Now, of course, if a boat has a coastwise endorsement, then you have to have citizens, or up to 25% can be lawful permanent residents. But you can't have non-resident aliens. You can on a boat with only a recreational endorsement. So why haven't people been hiring foreign crew, which are cheaper, for U.S. documented yachts? The answer was they couldn't get visas. The B-1 visa, which is what most yacht crew use to enter the U.S., until very recently only applied for foreign flagged yachts. There's something called the Foreign Affairs Manual, which is sort of a handbook that the State Department publishes that guides consular officials who are issuing these visas, and it has very detailed criteria for each of the visa categories. And there's even an entry for foreign yacht crew. And previously it said that the yacht had to sail from a foreign home port. And that had been interpreted to mean that regardless of the yacht's actual base of operations, the yacht has to be foreign flagged or you're not eligible for the visa. That's changed. Sometime in late 2019, they very quietly deleted that language. And we immediately started asking CBP, does this mean we can hire foreign crew? Does this mean we can hire foreign crew? And only a few months ago did CBP come back and confirm in writing that, yes, it does. There's a caveat. You have to show that the boat regularly cruises outside U.S. waters. So generally, when foreign crew come in with their visa, they have a letter from the captain that says they'll be working on this yacht, this is their employer, they have a permanent residence outside the U.S., here's the address. Going forward, if they're going to be working on a U.S. documented yacht, we suggest that you include an itinerary or some other evidence of plans to leave the U.S., because that's something that you have to prove to the CBP officers' satisfaction. They have wide discretion in who they let into the country, and this is a relatively new change, so many people in the field may not know about it. But CBP has told us that this does mean that you can hire foreign crew. Now, there are other requirements that may prevent you from hiring foreign crew. This is just for visas, just for immigration purposes. I already mentioned that if the vessel has a coastwise endorsement, there's a requirement that the crew be U.S. citizens. If the vessel is over 200 gross tons, then the Officers' Competency Convention applies, and that means that the master, the first officer, have to have Coast Guard credentials that you can only get as a U.S. citizen. So there are other requirements that may prevent you from hiring foreign crew to work on U.S. documented yachts. This does not mean that they are absolutely allowed, but a major obstacle to hiring them has been removed because now they can get B-1 visas. One other thing I should mention about visas: if a yacht is in charter, if it's bareboat charters, that's considered a pleasure use, not a use in trade, so the B-1 visa will work. The B-1 visa is a very convenient, very flexible visa. You typically have to return to your home country twice a year. If the boat is engaged in time charters, that's a very different matter. Time charters are considered a commercial use. And for the visa that yacht crew use, the B-1 visa is not for commercial vessels, it's only for recreational vessels. So if you want foreign crew on a time charter, they have to use a C1D visa, which is the same thing that crew on merchant vessels coming into the port use, which is good for 29 days, and you have to come in and leave on the same vessel. Very inconvenient. So if the vessel is being used for time charters, as a practical matter, you're probably not going to be able to hire foreign crew because the only visa that's available has a lot of strings attached. Okay, the last thing I want to talk about is foreign trade zones. So foreign trade zones have been really popular since they were introduced in South Florida, a way to bring in yachts that are foreign built, non-duty paid, and have them be exhibited here to U.S. residents. Sort of a new and more flexible version of the boat show bond. Has some downsides. The owner can't use the boat. You have to get permission to take the boat out of the FTZ to sea trial. But generally, they've been very successful. And until recently, we were even able to do closings in FTZs. There were some rules. For example, you can't actually have a closing on board. The closing itself has to take place outside the FTZ, had to take place outside the FTZ. And upon exiting the FTZ, you still had only two options. And those were either import the yacht and pay duty, or clear out and go foreign, go over to Bimini or whatever. Well, we had a bulletin that came in from CBP on April 1st of this year that said that, in their opinion, the rules no longer permitted sales to close within an FTZ. And my understanding is that they have made exceptions on a case-by-case basis for yachts that were already entered into an FTZ when they made that announcement. But I don't know of anyone who's been able to close in an FTZ since then. And we haven't advised our clients to try that. What you can do is you can still show the boat in an FTZ, but then if you want to close, you have to either import the boat or go foreign. So it's a little bit less convenient. You know, I understand that customs brokers and others are sort of lobbying CBP to change this interpretation. It's complicated because although CBP enforces the FTZ rules, they're actually made by a board in the Department of Commerce. And like a lot of other sort of legal things in the world of yachts, we're dealing with rules that were never designed for yachts. They're designed for just cargo and goods and not things that, sail around on their own bottom and that people buy in a customs facility. So we'll see where that goes. We'll see if it dampens the enthusiasm about FTZs. But for now, you can't close in an FTZ. So that's everything that I wanted to cover as part of the regulatory update. I hope that leaves some time for questions.
Perfect. Thank you, David. As I had mentioned earlier this morning in our opening comments, the deferred importation was a potential answer to what we're solving with the FTZ as kind of a Band-Aid measure. And while we haven't been able to prevail with the deferred importation goals, you've been there to DC with us to help support that. We are going to continue to monitor that closely and look for the opportune time to bring deferred importation forward. So it would either be the suspension of duty entirely under Brian Mast's bill, or a shift in time from the duty having to be collectible prior to offering the vessel for sale to a time at which the transaction takes place that the duty would be collected, like sales tax. I have a question over here.
Thank you. If a U.S. Coast Guard documented vessel has registry for foreign waters, recreational for owner use as private pleasure, and also commercial endorsement or coastwise endorsement, sorry, which one has more weight as to the 25% crew on the B1? If both is basically in the COD?
It's unrelated. The endorsement on the vessel's registry, no, I guess it is related to the visa, because if it has only a recreational endorsement, then it's definitely a recreational vessel. Coastwise, vessels that carry a coastwise endorsement, actually, and a registry endorsement, have to have U.S. citizen crew. The exemption's only for recreational vessels. You can't have any other endorsement.
I know we've got a question from this inquisitive group on this side of the room. Somebody has to have a question for David. I knew we'd get one from Kevin. That's why we kept you here to the end of the day, Kevin.
So, David, presumably you could still close international waters 12 miles, but then you've got to proceed to a foreign port before the boat can turn back around, reference the FTZ?
Well, that's kind of an interesting question, because my understanding of how the FTZ works is that the bond isn't cleared out until you actually go foreign. You have to import the boat into you have to touch it a foreign jurisdiction before the bond is cleared. So I don't think that you could leave the FTZ, close en route to Bimini, and then clear out the bond there. I think you would have to actually reach the foreign port and close there.
Who else has a question for us? Oh, got one back here. Man, I'm going to lose weight today.
The B1 visas, you said with the U.S. flag vessel, there was a reasonable amount of time outside of the United States or in foreign waters. Can you say what the definition is of that? They
haven't put sort of a percentage or a number of voyages on it. I think if you can show them that the vessel, the word they used was regularly, that the vessel, has an itinerary that's going to take the vessel to foreign waters, that should be enough. I mean, as I said, a lot of it is up to the discretion of the officer, and they haven't given us very clear guidance beyond that word regularly. So obviously, the more the better.
Nobody else? Oh. Melissa, you're killing me. I'm wearing my sneakers next time. Jason, you got something, please, to make it easier?
Thank you. I wanted to comment with regards to closing the FTZ bond. You do actually have to touch Bimini under the current ownership, and then you can come back out and close an international. And with regards to closing in an FTZ, I was actually able to get one approved on Friday. So it can happen if they're in there prior to customs new ruling.
It was somebody who was in prior to April 1st, though, right?
Yes, it was.
And you had to have it approved by the assistant port director or something?
Yes, I did.
Yeah.
Yeah. So it can happen, but you do have to be in there before April 1st.
Awesome. Thank you. Anybody else? David, as always, you're a rock star. Thank you very, very much
Thanks,
for a
everyone.
great presentation.